Yes. Anybody for Yenami Egbo? Can you hear me?
My lord, we can hear my lord, but we are not in that matter.
My lord, A.E. Omilole.
A.E. Omilole.
Yes, appears.
Yes.
For the claimant.
Yes. Defendants not represented. Agorodi, I cannot hear you. Eju Agorodi for the defendants. So this is a judgment of the court. Can you hear me?
Yes, my lord.
The claimants commenced this suit by way of complaint filed on the 27th day of November 2020, pursuant to Order 3, Rule 2 of the rules of this court. On the 5th day of June 2023, the claimants sought and obtained leave of this court to amend their statement of facts, whereas the claimants claim against the defendants the following reliefs: a declaration that the 1st to 21st and 24th claimants who had conscientiously carried out their duties as academic staff of the second and third defendants are entitled to their salary arrears for the month of January to November and outstanding salary for the month of December, all in 2017, as well as salary arrears from January 2018 to December 2018. A declaration that the second, third, fifth, and 26th claimants who had conscientiously carried out their duties as non-academic staff of the second and third defendants are entitled to their salary arrears for the month of January to November and outstanding salary for the month of December, all in 2017, as well as salary arrears from January 2018 to December 2018. A declaration that the forced retirement of the claimants by the defendants was wrong, unlawful, null and void, and of no effect, and therefore the claimants are entitled to their monthly salaries till date as staff of the second and third defendants. An order compelling the first, second, third, and fifth defendants to pay to the claimants their salary arrears for the month of January to November and outstanding salary for the month of December, all in 2017.
My internet connection is unstable. That's what I said. Is it because it's glue? Yeah.
Participant P10. Kaduna Gorode.
Good morning, Council.
Host.
Yeah, sorry, my lord is joining us. Can you all hear me? Hello.
Yes, yes. I can hear you. It appears you
All
have
right,
a
thank you. My lord is joining us.
On the 23rd day of November, the matter came up for adoption of final written address. Counsel for the first to third defendant resurfaced with a notice of preliminary objection. Counsel for the first to second defendant identified his notice of preliminary objection and written address in support of the objection filed on the 17th day of November 2023 and a reply on points of law filed on the 23rd day of November 2023. Council adopted these processes and urged the court to grant the application. In response to the notice of preliminary objection, counsel for the claimant identified the written address in opposition to the preliminary objection filed on the 17th day of November 2023, and counsel adopted this process and urged court to dismiss this application. Regarding the substantive suit, counsel for the claimants identified a final written address filed on 17th day of October 2023, adopted the same and urged the court to grant all the relief sought. The defendant did not file any address. The precis of the case of the claimants is that the claimants were staff of the first, second, and third defendants. The first to 21st and 24th claimants were academic staff of various primary schools in Ogbia local government area of Bayelsa State, while the 22nd, 23rd, 25th, and 26th claimants were non-academic staff of state schools, Akolomon, Otobigi, and AML, respectively. The claimants had been diligently carrying out their duties as academic and non-academic staff of their respective primary school, notwithstanding the failure of the first and third defendants to pay their monthly salaries as at when due and for over 1 year. Due to the inability of the defendants to pay as at when due the salaries of the claimants, the first and third defendants decided to carry out a series of staff verification ostensibly to reduce the staff strength. In all these exercises, the claimants participated and were not found wanting. That at present, the first, second, third, and fifth defendants are owing the claimants salary arrears of well above 24 months. When the first and third defendants finally commenced the payment of salaries of staff of the second and third defendants in the month of October 2018, the claimant realized that their names had been arbitrarily and unlawfully removed from the salary voucher of the first and third defendants, and they are ordered to proceed on retirement in spite of the fact that the claimants were not due for retirement, that their employment as academic and non-academic staff of the second and third defendants subsist, and therefore are entitled to their salaries owed them by the first, second, third, and fifth defendants from 2017 till date, that the act of removal of their names from the salary voucher by the second and third defendants and their subsequent forced retirement when they were yet to attain retirement age is arbitrarily unlawful and contrary to the provisions of the public service rules. The first and second defendants, by notice of preliminary objection and written address in support of the objection filed on the 17th day of November 2023, wherein the first to second defendants prayed the court for the following orders: an order dismissing or striking out the suit number NICM YEM 54-2020 for lack of jurisdiction, and an order of this honorable court striking out the name of the first defendant from suit number NICM/YEN/54/2020, and then the omnibus prayer. And the grounds upon which this application is brought by the first, second defendants are as follows: A, that no pre-action notice was served on the second defendant as required by section 29 sub 2 and 3 of the Bayelsa State Universal Basic Education Board Law 2005 as amended, being a body created by section 7 and 8 of the same law, thereby robbing the court of the jurisdiction to entertain the matter.
Secondly, that the claimant's amended statement of facts, the witness deposition on oath, do not comply with Rules 2A, 3A, and B of the National Industrial Court of Nigeria Practice Direction 2022. As such, this court is under a compulsory duty to strike out the entire suit as ordained by Rule 3 sub B1 of the National Industrial Court of Nigeria Practice Direction 2022. And thirdly, that there is no cause of action against the first defendant. In respect of the preliminary objection, counsel for the first to second defendants raised 3 issues for determination of this application, to wit, whether the non-service of pre-action notice on the second defendant does not rob this court of jurisdiction to entertain this suit. And secondly, whether the failure of the claimant to comply with, with Rule 2A, whether the failure of the claimant to comply with Rule 2A, 3AB of the National Industrial Court of Nigeria Practice Direction 2022 is not fatal to the claimant's case, and whether if there is no cause of action against the first defendant, for this court will not strike out the name of the first defendant from this suit. Counsel for the claimant raised also 3 issues for the determination of this application. 1, whether the first and second defendants' joint preliminary objection is not liable to be dismissed on grounds of incompetence, and secondly, whether the claimants failed to comply with the provisions of Rules 2A and 3AB of the National Industrial Court of Nigeria Practice Direction in instituting this suit, and thirdly, whether this suit discloses a reasonable cause of action against the first defendant. In respect of the preliminary objection, a perusal of the issues nominated by the claimants will undoubtedly show that issues 2 and 3 are replacement of the issues nominated by the first to second defendants. Therefore, I adopt issues nominated by the first to second defendants for the determination of this application, and adopt the sole issue nominated by the claimant in respect of the substantive suit. For the avoidance of doubt, issues for the determination in this suit are as follows. A, whether the non-service of a pre-action notice on the second defendant does not rob this court of jurisdiction to entertain this suit, and secondly, whether the failure of the claimant to comply with Rules 2A, 3AB of the National Industrial Court of Nigeria Practice Direction 2022 is not fatal to the claimant's case, and thirdly, whether if there is no cause of action against the first defendant, this court will not strike out the name of the first defendant from this suit, and fourthly, whether the claimants have proved their case to be entitled to the relief sought. I will skip your legal submissions and I will go to the court decision. Can you hear me? The
Yes,
objection of the objection of the first to second defendants touches on the competence of this suit. It is not out of place to reiterate that issues bordering on jurisdiction are very important and ought to be decided before adjudicating on the substantive matter. The court must first of all be competent, that is, have jurisdiction before it can proceed on any adjudication, as it is a fruitless venture to decide the merits of a case without jurisdiction. If a court or tribunal is not competent to entertain a matter or claim or suit, it is a waste of valuable time for the court to embark on the hearing and determination of the substantive matter. Therefore, it is an exhibition of wisdom to have the issue of jurisdiction or competence of court determined before embarking on the hearing and determination of substantive matter. See the decision of the Supreme Court in the case of Manome against Dakat, reported in 2022, 15 NWLR Part 1853 at page 231. Having established the priority of the application of the first to second defendants, I will consider the application first. Thus, the outcome of the decision of this court on the merit of the application will determine whether the court will proceed to the substantive suit or not. On issue 1, the gravamen of the first to second defendants on this issue is that the claimants did not serve the second defendant with pre-action notice as required under Section 29 sub 2 and B of the Bayelsa State Universal Basic Education Law, Board Law 2005 as amended. Counsel for the first to second defendant submitted that the failure of the claimants to serve a pre-action notice on the second defendant as required by Section 29 sub 2 and B of the Bayelsa State Universal Basic Education Board Law 2005 as amended, being a body created by Section 7 and 8 of the said law, deprive this court of its jurisdiction to entertain this matter. Counsel for the claimant submitted that the Bayelsa State Universal Basic Education Board Law 2007, which repeals and reenacted the Bayelsa State Universal Basic Education Law 2005, established the second defendant, Ogbia Local Government Basic Education Authority. The law regulates the action and activities of the second defendant, including the institution of action against the second defendant. The first and second defendant's preliminary objection is constituted is grossly incompetent, as the same offends the provision of Bayelsa State Universal Basic Education Law 2007, as well as National Industrial Court of Nigeria Civil Procedure Rules 2017, and therefore the preliminary objection is liable to be dismissed. First thing first, counsel for the first to second defendants cited a wrong provision of the law. The provision of Section 29 of Bayelsa State Universal Basic Education Board Law 2005 as amended relates to or deals with another matter outside the context of the premise of the objection filed by the first to second defendants. But notwithstanding that, Section 32 sub 2 of the repeal and enacted Bayelsa State Universal Basic Education Board Law 2007, which is relevant to the preliminary objection, provides that, and I quote, no suit shall be commenced against the board or any member, officer, or employee of the board or other bodies established by the Bayelsa State Universal Basic Education Board Law, except at the expiration of 1 month notice duly given to the proposed defendants, and the notice shall state the course of action, the particulars of claim, and the name and place of abode of the intending claimant, unquote. Under the provision of Section 36 of Bayelsa State Universal Basic Education Board Law 2007, it defines bodies as used in Section 32 sub 2 of the Bayelsa State Universal Basic Education Board Law 2007 as the State Universal Basic Education, Local Government Education Authority, District Education Committee, and School Committee. Looking at the defendants in this instance suit, by a combined reading of Section 32 sub 2 and 36 of Bayelsa State Universal Basic Education Board Law 2007, the second defendant is given a right to demand compliance with Section 32 sub 2 of the Bayelsa State Universal Basic Education Board Law 2007. Without gainsaying, the competence of a court in the exercise of its jurisdiction is determined if A, it is properly constituted with respect to the number and qualification of its membership, B, the subject matter of the action is within its jurisdiction, C, the action is initiated by due process of law, and D, and any condition to the exercise of the jurisdiction has been fulfilled. See the cases of Amadu against Ajiboye, Madukole against Nkendelen, AG Federation against Guardians Newspaper Limited. In this instant case, the objection of the first to second defendant is premised on the fulfillment of any condition to the exercise of the jurisdiction. The question to be asked here is whether the claimant has fulfilled the condition to the exercise of the jurisdiction as required in Section 32 sub 2 of the repeal and reenacted Bayelsa State Universal Basic Education Board Law 2007. I have carefully gone through the paragraphs of the claimant's amended statement of facts. I cannot see any paragraph that discloses that the claimant served the second defendant with a pre-action notice before filing the suit. A pre-action notice connotes some form of legal notification or information required by law or imparted by operation of law, containing an enactment, agreement, or contract which requires compliance by a person who is under a legal duty to put on notice to the person to be notified before the commencement of any legal action against such a person. The effect of non-compliance with the service of pre-action notice amounts to an irregularity. Where the objection to jurisdiction is founded on non-compliance with the requirements of a pre-action notice, it does not abrogate the right of a plaintiff to approach the court or defeat his action or defeat his course of action. Therefore, if the subject matter is within the jurisdiction of the court, the failure of the claimant to serve the pre-action notice on a defendant gives the defendant a right to insist on such notice before a claimant may approach the court. In other words, non-service of a pre-action notice merely puts the jurisdiction of a court on hold pending compliance with the precondition. A failure to serve a pre-action notice amounts to an irregularity that renders a suit incompetent. See the cases of Netero against Nigerian Port Authority, Niger Care Development Company Limited against Adamawa State Water Board, Chijioke against Chukwu, Ayeni against Obasa, Satumari against Emmanuel, Fan against Auto Fort Nigeria Limited, and Sarkinyaki against Bagudu, all citation provided. Though the service of the pre-action notice on the second defendant can be waived by the second defendant. However, the second defendant can insist on the compliance of Section 32 sub 2 of the repeal and re-enacted by Alsa State Universal Basic Education Board Law 2007. In the case of Niger Care Development Company Limited against Adamawa State Water Board Supra, the Supreme Court held, and I quote, while the issuance of the notice by a prospective plaintiff is mandatory, the particulars to be included in the notice, that is the cause of action, particulars of claim, name and place of abode of the intending plaintiff, and the relief to be claimed are directory. The failure to serve a pre-action notice on the defendant gives such a defendant a right to insist on such notice before a plaintiff may approach the court. In other words, that non-service of a pre-action notice merely puts the jurisdiction of a court on hold pending compliance with the precondition. A number of cases were referred to therein. In fact, failure to serve the said notice amounts to an irregularity that renders the suit incompetent, unquote. Thus, non-service of the pre-action notice on the second defendant makes the jurisdiction of this court inquired against the second defendant. Another pertinent question that deserves the response of this court is, what will be the fate of the case of the claimants in view of the fact that there are other defendants, first, third, fourth, and fifth defendants, who are to the best of the knowledge of this court not protected by any law to be served with a pre-action notice? I do not think that this suit can be defeated, even though the suit will be discontinued against the second defendant, while the suit is competent and maintainable against the first, third, fourth, and fifth defendants. See the case of Ojo against National Pension Commission, where the Supreme Court held, and I quote, the submission of the appellant that a pre-action notice is mandatory and a condition precedent for instituting a suit is true, to the extent that the party entitled to the pre-action notice raises the objection timeously, since the right can be waived, and it inures only to the party entitled to the pre-action notice, which in the instant case is available to the first respondent only, and not the second respondent cross-appellant. Having struck out the action against the first respondent, the second respondent cross-appellant does not enjoy the protection offered to the first respondent. The action is still valid against the second respondent cross-appellant. The appellant must give the pre-action notice to the first respondent before they can maintain an action against the first respondent, unquote. Flowing from the foregoing, this suit is incompetent against the second defendant, and it is hereby struck out only against the second defendant. The name of the second defendant is struck out as if he was not part of the suit at all. Issue 1 is hereby resolved in favor of the first to second defendant, and I so hold. On issue 2, where the first to second defendant challenge the competence of this suit based on the provisions of Rules 2A, 3A, B1 of the National Industrial Court of Nigeria Practice Direction 2022, counsel submitted that the attached document must be marked serially in the manner done for originating summons. Submitted further that the claimant's pleadings are not marked at all, as required by the rules, and urged the court to give effect to Rule 3B of the National Industrial Court of Nigeria Practice Direction 2022. Counsel for the claimants submitted that the claimants complied with the National Industrial Court of Nigeria Civil Procedure Rules 2017, as well as the court's direction. The claimant's complaint dated and filed on the 22nd day of November 2020, which was later amended on the 14th day of June 2023, is accompanied by the witness statement, to which I attach all the documents and claimants pleaded in their statement of facts, as well as the written statement of the witnesses, and serve same on the defendants in compliance with the provisions of Order 3, Rule 8 and 9 of the rules of this court. Order 2A of the National Industrial Court of Nigeria, filing of application motions in trade union matters and marking of exhibit Practice Direction number 1, 2022, provides that, and I quote, in the case of claimant, the statement of facts and the witness statement on oath must clearly indicate all the documents to be relied upon at the trial of the case and attach same. The attached documents must be marked serially in the manner done for originating summons, unquote. It is pivotal to note that this suit was commenced on the 27th day of November 2020, while the practice direction of this court came into effect on the 13th day of June 2022. Thus, I do not think that the practice direction of this court applies to this suit. Though counsel for the first to second defendants made a valid point that the practice direction of this court applied to this case, inasmuch as claimant thought and obtained the leave of this court to amend their statement of facts on the 5th day of June 2023. But I am not convinced, in the light of the decision of the Court of Appeal in the case of Nigerian Airways against Bajumo, where the court held, and I quote, "The effect of an amendment is that when duly made, it takes effect not from the date when the amendment is made, but from the date of the original document which it amends. This rule applies to every successive amendment of whatever nature and whatever stage the amendment is made. It is set law that when an amendment is made to the writ, the amendment dates back to the date of the original issue of the writ, and the action continues as though the amendment has been inserted from the beginning," unquote. If an amended pleading, the amended statement of fact in this instance suit, will be treated back when the suit was originally instituted, not when the order to amend was made. I see no logic in saying that the practice direction which came into effect on the 13th day of June 2022 will have a retrospective effect on the suit that was commenced on the 27th day of November 2020. For this reason, the National Industrial Court of Nigeria filing of application motions in trade union matters and marking of exhibit practice direction number 1, 2022 does not apply to this suit, and I so hold. Looking at the National Industrial Court of Nigeria filing of application motions in trade union matters and marking of exhibits practice direction number 1, 2022 from another angle, the practice direction was not issued to shut out the door of justice against anybody. The essence of the practice direction is issued to guarantee continued access to justice and expeditious disposal of cases. See paragraph 2 of the practice direction. Unfortunately, counsel this day will be urging the court to feather the wings of technicality and thereafter turn around to accuse the court of giving technical justice when the tone of the rule of law pricks them in the foot. Rules of court which include practice direction are not intended to be applied slavishly, particularly if such application will do injustice to a case. Accordingly, a court will prefer to do justice rather than injustice on the account of slavish adherence to the rules of court. See the case of PDP against INEC. Given the foregoing, issue 2 is resolved in favor of the claimant, and I so hold. Can you hear me? Can you
Yes,
hear
my
me?
lord.
Yes, my lord, we can hear you.
Yes, my
I
lord.
call places.
On issue 3, the first to second defendant submitted that the this principal release 1 to 3, as contained in the statement of facts, have nothing to do with the first defendant. The first defendant is not supposed to be made a party, as none of the claimant was working under the first defendant as shown by the claimant's amended statement of facts. The claimant submitted that the claimants in paragraph 1, 31, 32 to 37 of the amended statement of claim have pleaded that they are staff of the first, second, and third defendants. Secondly, the claimants are particularly pleaded in paragraphs 32, 33, and 34 that the first to third defendants carried out verification exercises to reduce their staff strength, and in all the exercises they participated and were not found wanting. The first, second, third, and fifth defendants owe the claimant salaries arrears of well over 24 months. That a community reading of paragraphs 31 to 37 clearly discloses a reasonable course of action against the first defendant. In resolving this issue, it is important to point out that parties must be consistent in the presentation of their case. Counsel's submission must always be received in the light of the prayers placed before the court. Thus, not every word used by counsel in the course of making his submission to court should be subjected to microscopic examination, such that the oral submission is allowed to supplant the reliefs properly made on the notice of motion. See the case of A. Manuf Industry Nigeria Limited against Akiode. Counsel for the first and second defendant by their application wanted the first defendant to be struck out on the ground that there is no cause of action against the first defendant. But counsel now turn around 360 degree in his address to say that the first defendant ought not to be joined to this suit, as none of the claimant was working under the first defendant, as shown by the claimant's amended statement of facts. Submission of counsel does not support the prayer 2 of the application of the first and second defendants. To determine whether or not a suit discloses a cause of action and the relief sought, the courts are required to examine the averments in the pleadings and see if they disclose a reasonable cause of action. Once a statement of claim raises some issues of law or facts calling for determination by the court, the mere fact that the case is weak and not likely to succeed is not grounds for striking it out. Thus, a pleading can only be said to disclose no cause of action where it is such that nobody can understand what claims the defendant is required to meet. See the case of Aomang against National NSA, reported in 2021, 10 NWLR Part 1783 at page 55. Having carefully gone through the pleading before this court, paragraphs 1, 5, 31, 32, 33, 34, 35 of the amended statement of facts, and really 3, 4, and 5 therein disclose reasonable cause of action against the first defendant. Flowing from the foregoing, this suit discloses a reasonable cause of action against the first defendant. Issue 3 is hereby resolved in favor of the claimants. The objection of the first and second defendants partly succeeds. The 3 orders sought by the first and second defendants are refused, but the second defendant is struck out from this suit for the failure of the claimant to serve the pre-action notice on the second defendant, and I so hold. Having dismissed the notice of preliminary objection filed by the first to second defendants, I will now proceed with the substantive suit. On issue 4, which relates to whether the claimants were able to establish their case, the claims of the claimants before this court are in two facets. A claim for declaration that they are entitled to their salaries arrears and to direct the first, second, third, and fifth defendants to pay their salaries arrears for January to November and the outstanding salary for December all in 2017, as well as salary arrears from January 2018 to December 2018. And the second claim is for a declaration that their forced retirement was wrong and unlawful and therefore null and void, and an order for reinstatement. It is important to note that the defendants did not file a defense to the claim of the claimants. A defendant who does not file a statement of defense to the claimant's statement of claim is deemed to have admitted the facts pleaded by the claimant. See the case of Aderompe against Eleran. Even at the default of the defense, the claimants are not relieved from proving their claim. The court does not grant the claim of the claimant on the platter, but on the pleadings and the credible evidence presented before the court. A claim for relief of declaration, whether of title to land or not, is not established by an admission by a defendant, because the plaintiff must satisfy the court by cogent and credible evidence called by him to prove that as a claimant he is entitled to the declaratory relief. A court does not grant declaration on admission of parties because the court must be satisfied that the plaintiff on his evidence is entitled to the relief claim. It is for the plaintiff to prove his case and not for the defendant to disprove the plaintiff's claim. Therefore, where a plaintiff on his own evidence failed to prove his claim for declaration, his claim must be dismissed. Indeed, courts do not make it a habit or encourage the trend of making declaration of right either on admission by adverse party or default of appearance or pleading. In an action for declaratory relief, the court must satisfy itself by evidence properly adduced and not otherwise. See the case of United Bank for Africa PLC against F. Young. In proving the employment with the defendants, the claimants pleaded that the claimants were staff of the first, second, and third defendants. The first, the 21st and 24th claimants were academic staff of various primary schools in Ogbia local government, area of Bayelsa State, while the second, third, fifth, and sixth claimants were non-academic staff of the state schools at Akoloma, Otuabigi, and Emea, and they tendered exhibit CW001, CW001B, which are letters of appointment of the claimants, and exhibit CW002, CW002B, which are claimants' confirmation of appointment letters, CW003, and CW003B, claimants' conversion and promotion letters, and Exhibit CW004, CW004B, which are claimant staff verification slips. The law accords a measure of primacy to the documentary evidence as against oral evidence. This being so because most documentary evidence being in a permanent form is less susceptible to afterthought and thus more reliable than oral evidence. It is for this reason that a law, whenever documentary evidence is available in addition to oral evidence, it is used as a hanger on which the veracity or credibility of oral evidence is tested or assessed by the courts. See the case of Bello against Governor Gombe State. In this instant case, the claimants have been tendered their appointment letters, confirmation of appointment letters, conversion promotion letters, and staff verification claim slips establish their employment relationship with the defendant. The claimants pleaded and laid evidence to establish that the first, third, and fifth defendants are owing the claimant salary arrears of well above 24 months. When the first, second, third defendants finally commenced the payment of salaries of staff of the second and third defendants in October 2018, the claimant realized that their names had been arbitrarily and unlawfully removed from the salary voucher of the first and second defendants. This piece of evidence is never challenged or contradicted. The effect of unchallenged evidence of a witness is that same is deemed admitted and should be acted upon. See the case of Payemi against Oni. Given the uncontradicted evidence, given the uncontradicted evidence of the claimants on the issue of outstanding salaries of the claimant, it is therefore the finding of this court that the defendants are indebted to the claimants for the salaries arrears for January, February, March, April, May, June, July, August, September, October, November, and outstanding salary for December, all in 2017, as well as salaries from January to 2018 to December 2018. On the second leg of the claim of the claimants, the claimant pleaded that when the first and third defendants finally commenced the payment of salaries of staff of the first and third defendants in October 2018, the claimant realized that their names had been arbitrarily and unlawfully removed from the salary voucher of the first and third defendants. They were ordered to proceed on retirement, even though the claimants were not due for retirement. The claimants tendered Exhibit CW007A to O, which has statutory declaration of age of the claimants. The snag here is that the claimants did not provide evidence to lead the statutory declaration of age, which are Exhibit CW005A to O, of the claimants to their employment. That is, at what age were they employed? How many years were they supposed to spend in service? And how many years have they spent in service? These are pertinent facts that will enable the court to link Exhibit CW005A20, the statutory declaration of ages of the claimants, to their employment. In the absence of sufficient fact to establish that the claimants are not due for retirement, the court is helpless. Documents admitted in evidence, no matter how useful they could be, will not be of much assistance to court if the absence of admissible oral evidence by person who can explain their purport. See the case of Alao against Akano. In Abi against Central Bank of Nigeria, the facts are as follows. According to the appellant, he took ill on the 26th day of February 2001 and was admitted by the second respondent. The appellant stated that the third respondent negligently diagnosed, prescribed, and administers to him various drugs, including gentamicin, which made him permanently deaf. During the trial, he tendered Exhibits B and B1. Exhibit B was a reference form from the first respondent staff clinic issued on the second day of May 2001 by a doctor whose name was not stated, referring the appellant to Lagoon Hospital in Lagos. The exhibit read as follows, and I quote, "This gentleman sustained a hearing defect following treatment with gentamicin. Kindly evaluate and manage accordingly. Thanks," unquote. The appellant lost his case at the trial court, and the Court of Appeal, because he did not relate the contents of Exhibit B and B1, but he tendered the same as evidence that he was referred to Lagoon Hospital in Lagos for further evaluation. The contents of that referral letter cannot be discountenanced as relate to the fact that he was referred to a hospital and the purpose. The Court of Appeal dismissed the appeal, and the Court of Appeal held as follows, and I quote, "From the pleading and evidence of PW1, Exhibit B was tendered to establish the fact that the appellant was referred to the Lagoon Hospital, Lagos for evaluation and management. Where a document is tendered in evidence, and it is intended to prove of a specific point. The duty on the party who wants to relate and exhibit an aspect of his case is to say so explicitly and not leave the court to investigate the contents of the document. This is because the admitted documents, as useful as they could be, will not be of much assistance to the court in the absence of admissible oral evidence by a person who can explain their effort. Unquote. Given the failure of the claimants to relate Exhibit CW00580 to their employment, the second limb of the claim is bound to fail, and I so hold. In respect of the general damages and cost of litigation, there is no pleading in support of these claims. The assessment of damages should be based on the pleadings and the evidence adduced. And where there is no evidence to support a claim for damages, the claim should be dismissed. See the case of NIM against Space Bank Nigeria PLC. Flowing from the foregoing, the claim of the claimant succeeds in part. Relief 3, 5, 6, and 7 as contained in the amended statement of facts are refused, but I grant relief 1, 2, and 4 in the following terms. I declare that the first, 21st, and 24th claimant who had conscientiously carried out their duties as academic staff of the second defendants are entitled to their salary arrears for January, February, March, April, May, June, July, August, September, October, November, and the outstanding salary of December all in 2007, as well as arrears of salary from January 2018 to December 2018. Secondly, I declare that the second, third, 25th, 26th claimants who had conscientiously carried out their duties as non-academic staff of the third defendant are entitled to their salary arrears for January to December, all in 2017, as well as salary arrears from January 2018 to December 2018. Thirdly, I compel the first, third, and fifth defendants to pay to the claimant their salaries for January to December 2017, as well as arrears from January 2018 to 2019. Relief 3, 4, 7, 6, and 7, as contained in the amended statement of facts, are hereby refused for lack of evidence. All terms in this judgment are to be complied with within 30 days from today, without prejudice to right of appeal by both parties. I decline to award any cost, and judgment is hereby entered accordingly.
As the court pleases. A.E. Omelole, my lord. I am very grateful. I hope it's on. Yes, A.E. Omelole, my lord. I am very grateful for the well-detailed and considered judgment. I always commend my lord for his wisdom. I have learned a lot from this judgment, and I believe I will benefit from a copy of that judgment. I apply that. Yes, my lord.
I'll send it to Bayelsa.
As the court pleases. We are grateful, my lord.
Yes. The parties in the second matter, are they around?
Yes, my lord. We are present.
Yes, my lord, we are here.
Okay. Happiness. We cannot use this. It will be. Why is it interrupted? So why is this network not interrupting your own? My own is full. So network and this one are different. Because here you are wasting your credits. Maybe this one is your own. Well, this one is yours. Have they given you money?
Judge Mangi, Chevron, and IG of Police. Representation, please. Yes. Who are in this case? The case of Judge Mangi against Chevron Nigeria Limited.
Yes, my lord. My lord, we are here for the first defendant.
This is Honorable Court.
Yes, announce your appearance.
I am Dr. P. Leonard Friend.
Dr.
I'm Dr. PJ Fawe. PJ Fawe.
PJ Fawe. And
yeah.
Yes, Fawe and who?
M.E. Amakri Allison.
M.E. M.E. Amakri Allison.
Alice.
Yes.
Allow we appear for the claimants. Yes, my lord.
Yes. Yes.
Yes. My lord, with utmost, yes, my lord. My lord, with utmost humility.
Yes.
UN, initials, UN.
Yes.
Ngwobia, my lord. Ngwobia. Yes. My lord, Ngwobia is spelled N-G.
Yes.
W-O.
Yes.
B-I-A, sir. My lord, appearing with me.
Yes.
Yes, my lord. My lord, appearing with me is my learned colleague, Tochukwu Madu Eke. Should I spell, my lord?
No, Madu Eke appeared severally before me, so I know it's...
As the court pleases. Thank you, sir. My lord, we appear for the first defendant. Thank you, sir.
Yes. Second defendant not represented?
Apparently, sir.
Second defendant not represented?
No representation, so, no representation, sir.
I think I lost contact with the court. Okay.
The court device is muted.
Sorry, the court device is muted, sir. My lord, the court device is muted.
Yes, we're having
challenges. Okay. Mute this one.
Yes, can you hear me now?
Yes, my lord. You can hear my lord.
Yeah, it's better now.
Okay. The claimant commenced this suit by way of complaint filed on the 20th day of February 2018, pursuant to Order 3, Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, whereas the claimant claims against the defendants the following reliefs: a declaration that the claimant's dismissal or termination as a security personnel of the first defendant on the basis of the criminal allegation and charges leveled against him without the outcome of the trial process is wrong. Secondly, an order awarding the sum of 2,894,082 naira 75 kobo only in favor of the claimant as special damages for salaries and emoluments payable to the claimant from December 2014 to February 2017, when the criminal proceedings against the claimant were dismissed. An order awarding the sum of 50 million naira only as general damages for wrongful dismissal. The claimant predicated his claims on the statement of facts and witness statement on oath filed on the 20th day of February 2018, and reply and further witness statement on oath filed on the 20th day of October 2018. That the first defendant upon being served with the complaint filed an amended statement of defense and a witness deposition on oath on the 28th day of July 2022. The second defendant predicated its defense on the amended statement of defense filed on the 7th day of October 2018. The suit proceeded to hearing on the 21st day of November 2019, where the claimant called a sole witness. The claimant, who testified for himself hereinafter refers to as CW1, identified his deposition made on oath on the 20th day of February 2018 and further deposition on the 30th day of October 2018, and adopted same as his evidence in support of his case. CW1 thereafter tendered exhibit CW001 to CW007. On the 16th day of June 2022, the first defendant opened its defense. Mr. Balogun Musa, herein refers to as DW1, testified for the first defendant. DW1 identified his statement on oath filed on the 28th day of July 2022 and adopted same as his evidence in support of the defense of the first defendant. DW1 thereafter tendered exhibit CV001 to CV004. After the close of hearing of this suit, on the 4th day of December 2023, the matter came up for adoption of final written address filed by counsel. Learned counsel for the first defendant identified his final written address filed on the 16th day of October 2023 and reply on points of law filed on the 23rd day of November 2023. Counsel for the first defendant adopted these processes as his legal submission in the aid of the case of the defendant and urged this court to dismiss this suit. Counsel for the claimant identified his final written address filed on the 27th day of October 2023 and adopted same as his legal submission in the aid of the case of the claimant while urging this court to grant the claim of the claimant. The second defendant did not call any witness and also did not file any written address. Let me briefly state the case of the claimant. The case of the claimant is that the first defendant has a corporate social responsibility to its host communities, which includes the Kokolu and Mawan community. The first defendant, through the Kefes Rural Development Foundation, called for qualified persons from the respective communities to be forwarded for employment, for which the claimant's name was sent to the first defendant from Koluama One community. That sometime in the year 2009, the first defendant forwarded, amongst other names, the names of the claimant to police training school at Ikeja in Lagos State, for security and supernumerary training for 3 months, starting from the 1st day of June to the 1st day of September, all of 2009. Sequel to the above, he completed a training program for non-service establishments, such as that of the first defendant. He was designated as a spy police constable with force number 2217, wherein he was also issued a certificate. That he was thereafter asked to resume work as a security personnel with the security department of the first defendant at its premises, wherein the claimant discharged his duties effectively and efficiently, so that he was able to foil a plot of some youth of the Chevron host communities to protest at Chevron facilities against the non-payment of compensation sometime in 2012. That from when he resumed work as security personnel with the first defendant, he has always been paid his monthly salary and other emoluments amounting to the sum of 107,188 naira 25 kobo only by the first defendant directly to Claimant's Union Bank of Nigeria PLC account with account name George Kemeri Mukumo and account number 0029258265. that the claimant, being a trained security personnel, prepared and wrote a proposed plan to compensate and handle the issues arising from the Chevron host communities comprising the Kefes Rural Development Foundation to solve the possible threats or breakdown in the relationship between Chevron Nigeria Limited and the host communities. The sequel on the said proposal he made to the first defendant, as stated herein, the first defendant caused the men of the second defendant to arrest the claimant on the 16th day of September 2014 at Topcon, Wari, Chevron yard premises belonging to the first defendant on the allegation of threats against the lives of some top management staff of the first defendant, that he was subsequently arraigned before Wari Magistrate Court 1 in Delta State on 3-count charge on the 18th day of September 2014, for which trial commenced, and one Agbaje Michael, a security supervisor to Chevron, testified as prosecution witness against the claimant. After the conclusion of the trial, the claimant as accused person was discharged and acquitted of all the 3 counts charged leveled against him by the ruling of the magistrate court on a submission of no case to answer made by the accused, the ruling which was delivered on the 17th day of February 2017. Shortly after his arrest and subsequent arraignment before the Magistrate Court 1 Wari in Delta State, the first defendant disentitled the claimant, who was on court bail, from having access to the first defendant premises without any formal communication as to its decisions against him, if any, so that the first defendant took a step further to stop paying the salaries and other emoluments to the claimant since December 2014 till the commencement of this action without formally terminating his employment. That his community, Kolo Mawan community, through its paramount ruler, His Royal Majesty, King Solomon Edimangi, Kolu the 11th, as well as Kefes host community's youth president, wrote to the first defendant demanding, among others, to reinstate the claimant and also pay him his monthly salaries and other emoluments. But the first defendant also ignored the said letters. That the first defendant, in its reply to the letter written to it by the paramount leader of Kolu Amawan community, alleged that the claimant was recruited by the second defendant and deployed to the second defendant. And after his arrest and subsequent prosecution, it was the second defendant that redeployed the claimant, for which he was neither given any letter nor notification. Let me briefly state the case of the first defendant in brief. The first defendant stated that whenever the first defendant requires the services of spy police, it makes a request to the Nigerian police for required number of spy police, and the police in turn, following its statutory powers, solely recruit, train, and deploy the requested number of spy police. The first defendant over the years had requested and or applied for the services of spy police for the law. The first defendant in 2007 made a request to the Commissioner of Police, Edo State Police Command, for the services of SPY police. The Commissioner of Police notified the first defendant that on completion of the training, the police command will post the spy police personnel to the first defendant. The recruitment, training, deployment of spy police are the exclusive prerogative of the Nigerian police force under the law. As a result, the first defendant could not have forwarded and did not forward the name of the claimant or any other person as alleged. The police were responsible for fixing the remuneration of spy police officers and for promoting them like every other spy police. The claimant remained an officer of and in the employment of the Nigerian police force. That the posting or otherwise of the claimant as spy police to the security department of the first defendant was the exclusive prerogative of the second defendant. That the posting did not create any form of distinct and separate employment relationship between the claimant and the first defendant, other than the statutory relationship between the claimant and the second defendant. It made the monthly payment to the claimant on the directive of the Commissioner of Police Lagos State, who is under the control of and reports to the second defendant, who is the statutory employer of the claimants. That some management staff of the first defendant received threats to their lives. The first defendant reporting the threat to the Nigerian police force was a lawful step taken by the first defendant for the safety and security of all its personnel. Having made the report to the first defendant was not in the position to direct the first defendant or its personnel in law and in any manner they discharge their statutory duties, including the decision to arrest and arraign and try the claimant. And the defense filed by the second the defendant as follows. The second defendant stated that it is the routine procedure of maintaining supernumerary police officers that the second defendant gives consideration to persons already nominated and forwarded to it for training by the person or corporate body availing himself of services of the officer, that this procedure was duly complied with in respect of the recruitment of the claimant. The claimant was posted to the first defendant to discharge his duties as a supernumerary police officer at the facility of the first defendant. The payment of salaries and other emolument of the claimant was supposed to be paid to the Accountant General of the Federation. That the direction for such payment by the first defendant was made in the letter, reference number AB 4825/LSV637, dated the 30th day of November 2010, pleaded by the first defendant in paragraph 7 of the statement of defense, that the second defendant was not informed by the first defendant of the misconduct of the claimant, neither did it give the second defendant notice to redeploy the claimant, and the second defendant did not redeploy the claimant to any other persons or department. After the close of the party's case, counsel for the claimant nominated 2 issues for the determination of this suit as follows: whether the claimant has shown reasonable cause of action against the defendants, and whether the first defendant is stopped from raising the settled issue of reasonable cause of action. B, whether the claimant has proved his case against the defendants and is therefore entitled to all the relief sought. Counsel for the first defendant nominated 2 issues for the determination of this suit. First, whether this honorable court lacks the competence to entertain this suit by reason of non-disclosure of any reasonable cause of action against the first defendant by the claimant. And secondly, whether the claimant has proved his entitlement to the relief sought as against the first defendant. The issues nominated by parties are similar, though differently worded. Even at that, quick check on the record of this court delineates that this court has previously ruled on issue 1 raised by the parties. By the application dated and filed on the 28th day of May 2018, the first defendant prayed this court to strike out this suit against the first defendant for not disclosing a reasonable cause of action against the first defendant. The ruling on which was delivered by this court on the 22nd day of October 2018, where this court held that this suit discloses a reasonable cause of action against the defendants as averred by the claimant in his statement of facts. Judicial authorities have always maintained that a court has no power to review its own decision on a matter or revisit same once it has been given. At that point, the court is said to be functus officio, allowed the virus to set aside its judgment or ruling except under certain circumstances. See the case of Refuge Home Savings and Loans Limited against Garkuwa, reported in 2023, 12 NWLR Part 1897 at page 175. In Okachukwu against UBA, the Court of Appeal held, and I quote, "The question is whether this court has become functus officio. The learned senior advocate appearing for the applicant in arguing this point has lost the fact that similar issue was decided by this court in an earlier application in Okachukwu against UBA number 2 Supra. In the said motion, one of the grounds for the application was that the judgment was a nullity being tainted with fraud and impropriety. I agree with the learned senior advocate appearing for the appellant respondent that the issues was considered in that application, and this court passed its own decision on it on the 2nd day of December 2004. By that decision, this court has undoubtedly performed its task and has therefore become functus officio. Unquote. Given this foregoing, this court does not have jurisdiction to engage itself in the post-mortem of its earlier decision. Issue 1 is incompetent and it is hereby struck out. Consequently, I adopt issue 1 nominated by the claimants. For the clarity's sake, the only issue for the determination in this suit is whether the claimant has proved his case against the defendants and is therefore entitled to all the relief sought. I will skip your submission and I will go to the court decision. Can you hear me?
My lord, we can hear you.
Yes, my lord.
Yes, as the court pleases.
So I'm going to the decision, court decision now.
As the court
I have
pleases.
carefully distilled the pleadings, the evidence led by parties, and the legal submission of counsel for and against the claim of the claimants. I will not forget to mention that the reliefs or claim of the claimants are triangular. Viz, a claim against unlawful dismissal for termination of employment of the claimant with the first defendant. Secondly, special damages of unpaid salaries and emoluments payable to the claimant from December 2014 to February 2017, an award of general damages for the wrongful dismissal. These three claims revolve around the employment relationship because both the defendants are dribbling the employment of the claimant to avoid responsibility. Because both the defendants are dribbling this court with regard to the employment of the claimant so as to avoid responsibility. The starting point of the claim of the claimant is who is the employer of the claimant between the defendants. It is when the employer of the claimant is established that the court can delve into the propriety of the termination of the employment of the claimant. The claimant pleaded and led evidence to state that the first defendant through Kefes Rural Development Foundation called for qualified persons from respective communities to be forwarded for employment, for which the claimant's name was sent to the first defendant from Koloma 1 community. That sometimes in the year 2009, the first defendant forwarded, among other names, the names of the claimant to the police training school at Ikeja in Lagos State for security and supernumerary training for 3 months, starting from 1st day of June to the 1st day of September, all in 2009. He completed a training program for non-service establishments, such as that of the first defendant. He was designated a spy constable with force number 2217 and was also issued a certificate. That he was thereafter asked to resume work as a security personnel with the security department of the first defendant at its premises, wherein the claimant discharged his duties effectively and efficiently. The claimant tendered exhibit CW001, letter of recommendation dated 1st day of June 2009. In opposition to the argument and evidence of the claimant, the first defendant stated that whenever the first defendant required the services of a spy police, it makes a request to the Nigerian police force for the required number of spy police, and the police in turn, following its statutory powers, solely recruit, train, and deploy the requested number of spy police. The first defendant over the years had requested or applied for the services of spy police for the law. The first defendant in 2007 made a request to the Commissioner of Police, Edo State Police Command, for the services of spy police. The Commissioner of Police notified the first defendant that on completion of training, the police command will post the spy police personnel to the first defendant. The recruitment, training, and deployment of spy police are the exclusive prerogative of the Nigerian police force under the law. As a result, the first defendant could not have forwarded and did not forward the name of the claimant or any other person as alleged. DW1 tendered exhibit CV001 and CV002 as proof of this fact. The second defendant's pleading on this fact is in line with the argument and evidence of the claimant. That is, the second defendant admitted that it was the first defendant who forwarded the name to the second defendant for the training as spy police or supernumerary police. The trial principle of law is that an admitted fact requires no further proof. It is deemed established. Thus, when an allegation of a material nature is taken as admitted, there will be no need to adduce further evidence to prove the allegation. See the case of GCOC International Limited against Diamond Bank PLC. I am inquisitive, very inquisitive, to query whether the admission by the second defendant binds the first defendant. I do not think so, because each party represents its interest individually, and pleadings were separately filed and not jointly filed. Hence, the admission of the second defendant on how the employment relationship between the claimant and the first defendant was created cannot bind the first defendant. This position of the law is fortified in the case of Buhari against INEC, where the Supreme Court held, and I quote, I want to make another point. As the amendment in paragraph 9 of the petition affects first and second respondents on one hand, and the third and fourth respondents on the other hand, admissions to be valid must be made by the above two sets of respondents. This is because an admission by one set of respondents cannot bind the other set, unquote. Thus, the claimant is not relieved of the burden to prove that the claimant was employed by the first defendant. In the absence of admission, the court will resort to documentary evidence to find out who is the employer of the claimant. Considering Exhibit CW001, Kefas Communities Regional Development Council forwarded the names of two persons, Mr. Mina Samuel B. from Ezetu 2 community and Mr. Keme George from Koluama 1 community. I presume the claimant is the person named as Mr. Kemi George from Koluama community. First of all, Exhibit CW001 cannot metamorphose to be a letter of employment. It does not create a master-servant relationship between the claimant and the first defendant. Again, did the first defendant forward the name of the claimant to the second defendant as claimed by the claimant? This takes us to Exhibit CV002, which is a letter from the first defendant to the Commissioner of Police, Edo State Police Command. For emphasis, Exhibit CV002 reads as follows, and I quote, "Basic training of supernumerary police personnel. Dear sir, Chevron Nigeria Limited is in the process of having the police authorities recruit qualified persons for training as supernumerary police personnel. We are already working with commissioners of police of the affected state for recruitment of 55 spy drivers and 20 general duty personnel, totaling 75. Inquiries at the police headquarters Abuja show that the police training school Benin is now the only approved institution for training. Attached is a letter from the Inspector General of Police F Department is relevant. We'll appreciate if you can give approval for the training and advise us on the modalities. Our Patrick Origbe, Security Superintendent, will liaise with your office. His number is ... unquote. My understanding of the content of Exhibit CV002, as reproduced above, does not suggest that the first defendant has employed some persons and wanted the second defendant to train them as spy police. The first paragraph of Exhibit CB002 means that Chevron Nigeria Limited wants the police authorities to recruit qualified persons for training as supernumerary police personnel. Not that the first defendant has recruited or employed persons and wanted the police authorities to train them as spy police. By Exhibit CB002, the first defendant did not forward any name to the second defendant for training as supernumerary police personnel. In fact, it is the second defendant which forwarded a list, Exhibit CV001, containing 79 names, wherein the name of the claimant is number 19 to the first defendant. The content of Exhibit CV001, which forwarded 79 names to the first defendant, read as follows, and I quote, "Read list of eligible candidates for spy police. I forward herewith attached list of qualified candidates for spy police training at Police Training School, Benin. On completion of the training, the spy personnel will be posted to Chevron Nigeria Limited. Acknowledge receipt, please." Unquote. Exhibit CW001, CV001, and CV002 do not by any figment of imagination suggest any employment relationship between the claimant and the first defendant. This then reminds me of the importance of the letter of employment. The first defendant submitted that the failure of the claimant to show any evidence of a letter of employment from the first defendant is fatal to his case. The claimant's argument that he received his salaries and allowances from the first defendant will not avail him. Counsel for the claimant submitted that the absence of a letter of offer of appointment made to the claimant does not deny the relationship that existed between the claimant and the first defendant as being one of the employer-employee relationships. That the proof of the existence of a contract of employment need not to be written in all circumstances. By the express provision of Section 91 of the Labor Act 2004, a contract of employment could culminate into a form of oral, written, express, or implied by the conduct of the parties. And Section 73 of the Employees Compensation Act 2010 further reinforces this position when it defines an employee to be a person employed by the employer under an oral or written contract of employment, whether on continuous, part-time, temporary, apprenticeship, or casual basis, and also include domestic servants who is not a member of the family of the employer. It is the facts surrounding the relationship between the parties that are considered in determining whether such a relationship was an employment relationship. See the case of Ungum against Mobile Producing Nigeria Unlimited. That the facts in the instant case are that upon a letter of recommendation from Kefes Rural Development Foundation, KRDF, to the first defendant, the claimant was retained and sent for training at the Police Training School, Lagos, CXB-CW001. Upon completion of his training, the claimant resumed work at the premises of the first defendant sometimes in September 2009. I agree with the claimant that it is not in all circumstances that the failure to tender a letter of employment will defeat the claim of an employee. This court, my humble self, in the case of Mr. Ebiwe Lesson against Dalon Oil and Gas Nigeria Limited, suit number NICN/YEN/16/2022, the judgment which I delivered, where the court held, and I quote, given the admission of the defendants that the third defendant brought in Mr. Odi Leon and the claimant being his younger brothers to assist Mr. Levi Wilson for a monthly allowance, it is sufficient to establish the employment relationship of the claimant and the defendants. It is therefore the finding of this court that there is an employer-employee relationship between the claimant and the defendants, unquote. In that case, the claimant was not issued with a letter of appointment, but the defendants admitted to have employed the claimant. In this instance suit, the first defendant denies employing the claimant, while the second defendant maintains that it is the first defendant that employed the claimant. So there is no other way the court can determine who is the employer of the claimant in the absence of admission, except by tendering of letter of employment. Ordinarily, the terms and conditions that regulate and govern employment for services are embodied and contained in the letter offering the appointment or employment from the employer addressed to the employee, which, if accepted freely and unconditionally by him, will constitute a valid, binding, and legally enforceable agreement or contract of employment between them. It is therefore the free and unqualified acceptance of all the terms and conditions set out in the letter of appointment of the employee that forms the basis for the existence of a legally binding and enforceable relationship between him and the employer. In any action in which any of the parties claims a breach of any of the terms or conditions agreed to by the parties as set out in the letter of employment, the letter of employment becomes a sine qua non to the maintenance and success of the action. See the case of Omera against Nigeria Railway Corporation, reported in 2022, 10 NWLR Part 1838 at page 349. This instant case can be distinguished from the case of Mobile Producing Nigeria Limited against Johnson. The precis of the case of the first to 15 defendants in Mobile against Johnson, where the plaintiffs at the trial is that upon their success at the interview, they were offered employment into the security unit of the appellant, bear exhibits C1, C2, JR1 to JR6, with their salaries and emolument determined by the appellant. They were sent for training to the 16 and 17 respondents on basic guard duties. Thereafter, the first to 15 respondents were issued with exhibits G1 and G2 with a certificate of participation in the course, and subsequently resumed duty of securing the appellant's properties. The Supreme Court in Mobile against Johnson unanimously held that, and I quote, contrary to the provisions of the Police Act, evidence on record shows that the first to 15 respondents were recruited and were employed by the appellant under the common law. See exhibits AB, C1, C2 at page 17 to 24 of the record. Exhibit JR2 to JR6 at page 714 to 718 of the record. See also exhibit JR15, exhibit D, E, F, H, JR17, J, all as appear on the record of appeal. These exhibits clearly show that the interview of the first to 15 respondents and their appointment letters were issued and signed by the appellant. This was clearly in breach of Section 18 sub 1 of the Police Act. The appellant herein is not the appropriate authority empowered to appoint supernumerary police officers. It is the Police Service Commission, as defined in Section 224 of the Police Act. Nowhere in the Police Act is the appellant empowered to test, interview, and issue appointment letters to persons seeking to become supernumerary police officers, as was rightly held by the court below at page 947 of the record, unquote. Though the facts of the case of Mobile Producing Nigeria Limited against Johnson Supra and this instant case are almost the same, the area of difference between the two cases is that the claimant herein was not issued with a letter of appointment by the first defendant. It is based on the letters of appointment issued by the appellant that made the Supreme Court to conclude that the first 15 respondents were employed by the appellant. Let me dig further into this case. The first defendant maintained that the claimant is a supernumerary police officer of the second defendant, and the first defendant tendered exhibit CV001 and CV002. I have earlier reproduced the content of exhibit CV002, which was written to the Commissioner of Police, Edo State Police Command, for the services of spy police. If the claimant is a supernumerary police officer of the second defendant, as the parties want the court to believe, it then means the claimant was employed by the second defendant. The provision of the Police Act, which deals with the appointment of supernumerary police officers, are momentous here. But before going into that, I need to remind the parties that this suit was filed on the 20th day of February 2018. The prevailing Police Act that was in existence when this suit was filed was the Police Act 1990, while this suit is pending. The National Assembly repealed and enacted the Police Act 2020. Thus, the Police Act 2020 does not apply to this case. The law applicable to a cause or matter, and therefore the jurisdiction become competence of the court, is determined by the existing law or the law prevailing at the time the suit was filed, and not by the change of the existing law. It is immaterial that during the trial, the law had been repealed. See the case of Sosa against Foco, reported in 2001, 1 NWLR Part 693 at page 16. Who is a supernumerary police officer? A supernumerary police officer is defined by Section 2 of the Police Act, Laws of the Federation of Nigeria, 1990, as a police officer appointed under Section 18, 19, or 21 of the Police Act, or under an authorization given under Section 20 of the same Police Act. And Section 18 of the Police Act 1990 provides. I reproduce the Section 18. I'll skip it. When you see the record, you look at it. Section 18A, B, Section 5, 6, all. I produce it here. So when you get the judgment, you look at it. The Supreme Court in Mobile Producing on Nigeria Limited against Johnson Supra summarized the above provision. The process of appointing a supernumerary police officer as follows. 1. An application by a person who desired the services of a supernumerary police officer to the Inspector General of Police. On receipt of the application, the Inspector General of Police may, with the approval of the President, direct the appropriate authority to appoint such number of persons as supernumerary police officer as the Inspector General of Police may deem fit for the protection of the applicant's property. Thirdly, on appointment of such supernumerary police officer, an applicant shall pay to the Accountant General the full cost of the officer's uniform. He shall also pay quarterly the salaries of the officer and other costs as may be directed by the Inspector General of Police also to the Accountant General. By Section 22 sub 4 of the Act, appropriate authority is used in Section 18 sub 2 is defined as follows. The appropriate authority in relation to any power to appoint or determine the appointment of supernumerary police officers means the Police Service Commission or any superior police officer to whom that power has been delegated in accordance with Section 194 sub 1 of the Constitution of the Federal Republic of Nigeria, unquote. Let it be known that a supernumerary police officer is an employee of the Nigerian Police Force by Section 18 sub 2 of the Police Act. Supernumerary police officers are appointed by the appropriate authority on the directive of the Inspector General of Police, and by Section 20 sub 3C of supernumerary police officer shall be a member of the police force for all purposes and shall accordingly be subject to the provisions of the Police Act. For avoidance of doubt, Section 20 sub 3 of the Police Act provides, and I quote, every supernumerary police officer appointed under an authorization given under the Section A shall be appointed in respect of the police area to which the authorization relates. B, shall in the police area in respect of which area adjacent thereto, but not where have the powers, privileges, and immunities of a police officer. C, subject to the restriction imposed by paragraph B and C of this section, and to the provision of Section 22 of this Act, shall be a member of the post for all purposes, and shall accordingly be subject to the provision of this Act, and in particular to the provision thereof relating to discipline, unquote. Thus, if the parties herein wear the claimant the garb of supernumerary police officer, it does mean that the appointment or designation of the claimant as supernumerary police officer must comply with the provisions of Section 18 to 22 of the Police Act. Anything short of the provisions of Section 18 to 22 of the Police Act is a nullity. Exhibit CV002 is an application written to the Commissioner of Police, Edo State Police Command, for the services of spy police as against the Inspector General of Police, stipulated under the provisions of Section 18 of the Police Act. Though the claimant attended the police training and his subsequent deployment to the first defender via Exhibit CB001 by the second defender, the certificate of participation in the police training school tendered by the claimant, Exhibit CB001 and CB002, cannot cure the defect in the designation of the claimant as a supernumerary police officer of the second defender. This court cannot legitimize illegality in the designation of the claimant as a supernumerary police officer. I'm very certain, without hesitation whatsoever, from the gamut of the evidence before this court, that the defect in the appointment of the claimant as a supernumerary officer is as follows. 1, that the first defendant did not write an application requiring the services of a supernumerary police officer to the Inspector General of Police. 2, there is no evidence before this court that the Police Service Commission had a hand in the employment of the claimant. And 3, there is no evidence of payment of the appropriate fees to the account of the Accountant General of the Federation. In Mobile Producing, Nigeria Limited against Johnson Supra, the Supreme Court held that, and I quote, it follows that in considering whether the first to 15 respondents were appointed as supernumerary police officers, it is the provisions in Section 18 to 22 of the Police Act that must be considered to determine if such appointments were done in conformity with the provisions of the law creating such employment. As was rightly submitted by learned counsel for the first to 15 respondents, where a statute has provided for the method of doing anything, must be done in accordance with the express provision of the statute. It is a trite law that when a law provides a particular way or mode of doing a thing, and unless such a law is altered or amended by the legitimate authority, then whatever is done in contravention of those provisions amounts to a nullity and of no effect whatsoever. Unquote. In conclusion, it is my finding that the claimant was not employed by the first defender. Failure of the claimant to tender the letter of employment of the claimant to prove that the claimant was employed by the first defendant is fatal to the case of the claimant. Again, the procedure for the appointment of the claimant as supernumerary police officer of the second defendant is tainted with obvious disregard to the provisions of Section 18, 19, 20, 21, and 22 of the Police Act. Though I deeply sympathize with the claimant, but sentiment has no place in our judicial proceedings. The claim of the claimant is prone to fail and sink. Flowing from the foregoing, the sole issue for determination is hereby resolved in favor of the defendants. The case of the claimant is hereby dismissed accordingly, and I so hold. I make no order as to costs, and judgment is hereby entered accordingly.
As the court please.
As the court please.
As the court
My
please.
Lord, we are most grateful for the well-considered judgment. Thank you very much, my Lord.
As the court pleases, we are grateful as well.
Yes,
All right, sir. Congratulations.
Okay. Thank you very much. Thank you.
All right, sir.
Talk to you later.
Yes, I'll see you later.
Sure. Nice one. Hey, I'm not this white here. Oh my God.